Hey guys, this is Vicki and welcome back to Courtroom Clapbacks. I've got a case for you today. It's in circuit court where Judge George Mertz is overseeing a case with a young man named Mr. Poyer, who's been in jail right now for 136 days. And of course, the defense attorney is going to argue that Mr. Poyer does not need any kind of a long jail sentence because he has mental illness. And they don't help him there. So he just needs to get his medication figured out. Now, Mr. Poyer has a history with this court. This is the sixth time, number SIX. He has been charged with domestic violence. He's had 2 prior charges of aggravated stalking. He's had fleeing and eluding. He's had resisting and obstructing. He has had assault by strangulation. So, this is not a slap on your wrist kind of case. In fact, the prosecutor says, Judge, it wasn't that long ago, and his parents contacted me and said, we are afraid that our son is going to kill us. So we're going to head into the court and listen to the case and see what Judge Mertz decides. Everybody got your popcorn? You got your pop? Got a hot cup of coffee? Real quick, if you would be so kind as to hit like and subscribe to my small channel, it would be so appreciated. But that being said, court is now in session.
Are we ready on Mr. Poyer's matter?
We are.
Mr. Poyer, if you can come forward to the podium, please. We'll go on the record in People versus Poyer. This is file number 25-5471. The record should reflect that Mr. Poyer is present here in the courtroom today. Time set for sentencing in this matter. Or did you have a chance to go through the pre-sentence report and talk to Mr. Trees about that? Any additions, deletions, or corrections?
Your Honor, the jail credit will need to be updated at 112, but
136.
there we go. Mr. McFauld is much better at calculating it than I am. I'm always wrong.
So we'll correct the jail credit to 136 days. Any other additions, deletions, or corrections?
No,
Do you have any challenges to this point?
no.
Ms. Cope, do people have any additions, deletions, or corrections?
No,
Do you have any challenges to scoring?
no.
Do you have any victims that wish to address the court today?
It is my understanding that the victims are attending but do not want to speak today. They've already submitted a statement.
And anything that you wanted to indicate by way of allocation?
Your Honor, this case has been very difficult. The victims in this case, when it started, probably had more contact with me personally than any that I can remember. They talked to my victim advocate and wanted to come in and speak directly to me. They had several meetings with me. They came in and discussed this case with me, and I talked to them on the phone several times. They told me at the beginning of this case that they thought their son was going to kill them. And they told me that numerous times. They were very concerned. He then went out to the property to get the trailer with the police. They contacted me and discussed that. They were very concerned about their health and well-being. They talked about leaving their home. As the case progressed, they then decided that they didn't want to go forward with the case and it should be dismissed. This is not the first time I've dealt with them in this situation. We had a case a couple of years ago with domestic violence. The same situation happened. It wasn't as severe, and it had been dismissed for mental health. Mr. Poyer has a long history of mental health. He's 38 years old, but he has a juvenile record, 10 misdemeanors, 8 felonies. He has a very long assaultive history. He definitely has mental health issues, but he does not address those. His parents were the people who told me at the beginning of the case that he had quit going to all of his mental health treatment and he had made that choice himself. So we are stuck with a situation where the recommendation, frankly, is probably not going to work. Putting somebody in for 12 months with no time over their head just doesn't work. I think the recommendation would be better crafted to be a prison sentence that would allow him to get out with a mental health hold, which is similar to the prison sentence he just got out on, and would offer him much more services for his mental health, as well as when he got released, he would have much more mental health oversight. I spoke to Mr. McFauld about the services that would be available each way, and he would have more services if he went to prison. His guidelines are 10 to 23 months. Based on his criminal history, I don't see anywhere where he would be at the bottom end of the guidelines. Frankly, he's probably closer to the top end. I understand he has mental health issues and that has played into this, but I would ask the court to sentence him in the middle to towards the top end. Thank you.
Mr. Church.
Thank you, Your Honor. The recommendation here would contemplate a county jail sentence. So to an extent, I agree with the prosecutor, which is to say, you know, the idea of putting him in the county jail for a year, having him released on probation following the year in the county jail, with the court really kind of putting itself in a position of going to the extreme sanction of MDOC because all the county jail availability has been used up. I certainly can understand the rationale there and would tend to agree that I don't think that that's the best option. I think that puts the court in a position where the court has fewer options and fewer tools. What I think the right answer here is probably county jail up front with some held in abeyance. And obviously the court always knows that with any probationary term, if there's violations, the court has the option then to take corrective steps, which are much more significant. The court at that point would have the ability to assess what the violation is. And if that requires a county jail sanction or requires the step of an MDOC sanction. And frankly, I would probably even agree with the prosecutor insofar as if there's violations, the answer probably is MDOC. With that in mind, I don't think it can be overstated how much the mental health plays into this. And I think it's important to recognize the mental health from day one to where it is now. When I first interacted with Mr. Poyer, I think it would be an understatement to say that he was in crisis. He didn't understand what was happening. He wasn't thinking clearly. He wasn't able to articulate ideas clearly. He's been lodged for the majority of the time that this case has been pending. And while there, he's been getting treatment from the nurses and from CMH coming into the jail and assisting him. He presents today different than I think he did when he went in. So this begs the question, why would we think something different will happen if the court were to release him today or in the near future with a CMH type diversion plan, a jail diversion plan, similar to what we've provided to the court? And I think the answer is that he's going to have a different quality of care than what he was getting previously. When Mr. Poyer, in the time period leading up to these events, he was working with a psychologist. The psychologist, though, was in Grand Rapids, and all of his appointments were being done via video. They were trying to adjust his meds, but frankly, for someone with his level of needs, the idea that video visits would be sufficient is laughable. He needs someone who can be there and interact with him and see what's happening. And unfortunately, in sort of the post-COVID era, we've shifted to a lot of things being done via video that probably need more of a personal touch than that. As he's been working with CMH, they're recognizing that his medications were not right. He wasn't getting medicated at the right levels. And again, we know that when medicating someone, there's two problems that are equally bad, right? Under medicating someone is bad. Over medicating them often produces the same bad results, just in a different way. What happened with Mr. Poyer, I think, is he was being over medicated. He doesn't feel right when he's over medicated. And what does he do? He does what most people do, which isn't a smart idea, but we see people do it all the time. He self-medicates. He self-medicates with alcohol because he's trying to make himself feel right. He knows he doesn't feel right. He doesn't know how to fix it. He's not a doctor. So he starts self-medicating. We see the behavior a lot. Frankly, self-medicating with alcohol, there's very few situations, period, where alcohol makes it better. Our decision-making never gets better there. It certainly doesn't help mental health issues. I think the right approach here is to give him an opportunity to address his mental health needs. I think his parents would say, and as much as did in his dad, I should say, in the victim impact statement that was submitted, when he's on his meds and he's in his right mental state, he's a good guy. He's a productive member of the community, and he's not a danger. When his mental health isn't right, yes, he's a danger. The right way for us to deal with that sort of issue isn't to lock him up, which isn't going to help his mental health. And I recognize that that's only one piece of the puzzle here. But that's not gonna improve his mental health. And when he's released in a year or 13 months or 16 months or whatever the court imposes, he's not going to be in any better position than he is now. The right approach is to punish the behavior, to monitor him, and to have the ability to react if there's a violation. And I think that a blended sentence, having some jail up front, some held in abeyance, and to allow them to engage in the community mental health diversion plan is the right response. Thank you.
Thank you, Mr. Poyer.
I agree with you 100%. I'm not a violent person, and if I've been a violent person, it's because I drank. I didn't feel right. I'm just not a violent person. If you give me a chance to be in the community, show you that I can do right.
All right, well, I mean, I read through the report, Mr. Poyer, so I'm familiar with what happened in this particular case. I did get the information from your family, the letter that was submitted, some of the information from CNH and so forth that was submitted with the report. So I've read through all those materials. I'm also familiar with your history and your background. And so I try to, and I listened very carefully to what counsel had to say, which they take very opposite positions, but I think they both agree that some continued mental health treatment is absolutely necessary. I think the question is where from the court standpoint, which is completely different from, a social work or, a mental health treatment standpoint, we're here to deal with criminal conduct, and where the court can facilitate help with the underlying causes of that conduct. It's incumbent on the court to do that. But those resources are always going to be more limited than what you can get from the private sector. But the question here is, with what the court has within its control, where are those resources best going to come from? The prosecutor suggesting it's going to come through the state and the resources that are there. Mr. Trush is indicating that he thinks that locally there's better options. So those are kind of what I'm presented with, and they're both reasonable positions to take. So I look at both of those options, and then I also look at what has happened in the past, and what happened here, and what was your behavior here. And it's clear that for whatever reason, whether you're under-medicated, over-medicated, whether you just stop taking your medications, which there are some indications in this report that that's what happened. It's clear that this incident was brought on by mental health issues combined with the use of alcohol, and I think just some underlying issues that you do have. And when I look at your past history, that's certainly borne out. This is your 6th time being charged with a domestic violence offense. You've got 2 prior charges for aggravated stalking, fleeing and eluding, resisting or obstructing, assault by strangulation, It's not like this is your first assaultive offense. You've got a long history of that going back to juvenile offenses. So, I can appreciate that when things are going well, you're not a violent person, but you certainly have exhibited throughout your lifetime violent tendencies. And whether that's attributable all or in part to mental health issues or just a lack of self-control, I don't know, and I don't know that anybody does. But there certainly is plenty in your past history to suggest that you do have violent tendencies when things aren't going right. I also look at what kind of prior sentences. You had 4 prior terms as a juvenile on probation. You've had 5 prior terms as an adult on probation. And at some point, the court has to recognize that continuing to do the same thing over and over again when it's not working is not appropriate. And so for all of those reasons, I don't think probation is appropriate in this case. And I don't think a local sentence provides the best option for you going forward. And I don't think it provides the best options for the community. I think having you remain in the community, given your history of violent conduct, is dangerous. And prior attempts to supervise you in the community have not been successful because you're continuing to reoffend. So for all of those reasons, I do think a sentence at the higher end of the guidelines is appropriate. It addresses the conduct that you engaged in this case. It recognizes past failures and your past history. And I think it's a reasonable sentence. The court is going to sentence you to 23 months in the Michigan Department of Corrections to 5 years. You have credit for 136 days served. The court is going to order a crime victim's assessment of $130. Court costs of $325, attorney fees of $350. Mr. McFeld, I'm going to assume, based on the prior sentences, he's already had DNA testing.
Can I say something, Judge? I'm the father. Can I approach?
You can stay right there and you can tell me what you'd like.
I think that he deserves a different sentence than what you're giving him. I don't think he needs to be sentenced to prison. He can be a good person. What happened with us was out of hand, but like he said, it was an fault and everything. He can do right if he's on the right legs. He really can. I don't feel a fear from him when he's normal like that. He's like you said, he self-measured himself. And I think he deserves a break in society and do what he has to do. He can do that if he stays focused. I really think he deserves that. Prison's incarceration is not going to do any good. He's been there before. They didn't turn out good. They almost killed him down there. He almost died. The same thing's going to happen again. It doesn't do no good to lock him up. You don't get no help down him. They lock the key, throw it away. They do nothing. Don't help. Out here, you can get more help. What he needs, he has mental issues. That's what needs to be addressed. Okay, that's it.
Thank you. I appreciate your opinion.
Nope.
I'm sure he's had DNA testing, Judge. We're kind of not understanding fully if we're supposed to recommend that on every case or not. We've had kind of different opinions on that. So,
I understand. A $68 state cost. You do have the ability to seek an appeal of this sentence, Mr. Poyer or Mr. Trush. Do you have an acknowledgement of the appellate rights, Mr. Poyer?
I go over it with him right now. I have that for the case.
All right, guys, what do we think? What do we think about this case? I felt so sorry for the dad because I was thinking about, I wrote on that Love is Blind, and I was thinking about how when you're driving a car, there is a blind spot. if someone starts to pass you on the passenger side, a lot of times, even I guess on the driver's side, a lot of times you can't see it. If that car gets in the exact spot, there is a place where you don't see it, and it's called the blind spot. Everybody around your car can see that someone is getting ready to pass you, but you can't see it. That is your blind spot. And I thought about that when the dad got up and started talking, that he loves his son, and that is why he has that blind spot. He's not seeing clearly that recently they thought that his son could murder them. And now he wants him to have probation and to get back on his meds. But the judge made a point too, whether it's that he's over-medicating himself, under-medicating himself, or just deciding not to take the medication. Society is placed in danger as long as we're depending on this guy to take his medicine. So that was an interesting point. What are some of the points you guys felt like stood out? I was thinking about where, locking him up, where the defense attorney said locking him up isn't going to address the mental health. And maybe just give him a little bit of jail time and then put him in treatment. And then how Mr. Poyer himself said, I'm not a violent person. I'm violent only when I drink. But that is a choice that he makes to pick up that alcohol. And of course, if he is taking his medication, he's mixing alcohol and the medication together. And that can't be a good thing either. So the judge is sentencing him. He's talking about looking at his past behavior. Oh my gosh, when he talked about his past behavior, that he had 6 times been charged with domestic violence. 2 times he had prior aggravated stalking cases, fleeing and eluding, resisting and obstructing, assault by strangulation. What a history. He also talked about the history of him being on probation. 4 times he was given probation as a juvenile and 5 times as an adult. And everybody, the parents and Mr. Poyer himself, is asking for a 6th time probation trial. So, and the judge, I feel, was right, saying he is a danger to the public. So what do you guys think? The defense attorney was asking for, actually, it was a prosecutor who was asking for the high end, which was 23 months. And the judge actually gave him 23 months to 5 years sentence, which he probably knows with time served. Unless he gets into some serious issues in prison, he's going to be released earlier than 5 years for sure. The parents, the dad said, I'm not afraid of him when he's normal. So sad. I felt so sorry for him. My heart breaks for parents in that situation, because as a grandmother, I have been in that situation with one of my grandsons facing prison time, jail time. And I know it breaks your heart. But to me, I feel like when a child grows up, becomes an adult, and lives a life of criminal behavior, if as a parent or even a grandparent we had the ability, we would send them to their room. But they've outgrown that, and they've outgrown our authority. But when the judge sends them to jail, that is like sending them to their room. Sit there and think about why you're sitting in the jail right now. You need to sit and think about how you need to change your life. So it's like the government is sending them to their room. And to me, that's not a bad thing. That's a good thing. What do you guys think? Drop your thoughts down in the comments. I want to know what you think. So, that being said, this case is closed. Until next time, when you join me on Courtroom Clapbacks. Until then, court is adjourned.